Computer forensics. Computer forensics is the analysis of information contained within and created with computer systems and computing devices. Emphasis: computer systems and computing devices. Typically in the interest of figuring out what happened, when it happened, how it happened, and who was involved. The computer forensic process also involves the preservation, identification, extraction, interpretation, and documentation of computer evidence to include the rules of evidence, legal processes, the integrity of evidence, factual reporting of the information found, and providing expert opinion in a court of law or other legal proceedings. It is important to clarify that when the term computer evidence is used, it is also synonymous with the term digital evidence. And the term computer is not restricted to just your laptop, desktop, or computer server. It also includes mobile phones and any digital device that is capable of storing digital information. So essentially, computer forensics is concerned with resolving questions that relates to activities on digital devices as to the what, how, when, and more particularly the who is responsible for activities on computers and digital devices. Now, let us look at where digital devices may be located. First is the hard disk, then of course the USB storage, memory, network devices, and the internet. It is important to identify the sources of digital evidence. Having identified digital devices, because the identification of the source of the evidence affects the analysis of whether or not there was procedural compliance during the identification of the evidence, the extraction of the evidence, the analysis of the evidence. Now, with the hard disk, the species of digital evidence that is likely to be found in here will be locally saved files or deleted files, operating system files, application files, and very importantly, user profiles. With USB storage, these are usually attached to the computer and files are copied from or to these external storage. The USB external storage could come in the form of a USB stick or USB thumb drive, as some people would prefer to call it, or it could actually be in the form of a fully fledged hard disk that is connected to a computer via a USB connection. Either way, most of the files that you will find in an external storage would include user files, videos, pictures, but not operating system files or applications. Those can only be found in the fully fledged running computer systems. Now, the memory. The computer memory is home to active processes. What do we mean by active processes? When the computer is switched on, the memory holds very crucial information that may assist in resolving legal issues. For example, it will hold information concerning where the computer is connected to at that point in time. It may hold information as to the passwords being used on that computer. It may hold information with respect to what applications are running on that computer. But what is important here with respect to evidence from the computer memory is that that species of memory or those species of memory are only present when the computer is switched on and when there's power, electricity or battery power active at that point in time. Once power is removed from the computer or laptop, the contents of the memory are completely erased. So in terms of the computer memory as a source of digital evidence. Digital forensic engineers are interested in what is referred to as live acquisition, as opposed to what is referred to as dead acquisition. Live acquisition is when the forensic engineer, technician, or the expert acquires the computer or acquires the content of the hard disk and the memory of the computer while the computer is still switched on. That's called live acquisition, and the advantage there is that they are able to collect the contents of the computer memory. Dead acquisition refers to a situation where the computer is switched off. The difference between live acquisition and dead acquisition is that for dead acquisition, the expert or technician who is acquiring the evidence does not have the benefit of acquiring the content of memory. Now, network devices would be devices like the routers, switches, and hardware firewalls. Now, routers as network devices would have information, digital information, that relates to the connection activities of one computer to another within a network. They will show information concerning what time the connection was made, how long that connection was for, the source of the connection, and the identity of the destination connection. These are some of the information that can help to resolve questions surrounding whether or not information was shared between one computer and another, or one computer and the server within a network environment. Now, with respect to the internet, evidence of internet activities can be found on the local machine in the form of web pages showing websites visited, remnants of chat files, voice over IP files. Voice over IP files will be files generated by users who make or conduct telephone communication via their computers. Of course, you will have social website files like Facebook, Twitter, and you would have evidence of downloaded files. So all of these would combine to give a history of the internet connection from a particular computer. There is a more detailed aspect to how all of this is done on the technical side, but in terms of the species of internet-based evidence that you would find on a local computer, there would be web pages visited, chat files, evidence of chat files, voice files, and evidence of social network connectivity. Now, let's look at the life cycle of digital evidence. It is important to have a bird's eye view of the life cycle of digital evidence. This is helpful so you can properly analyze the relevance of digital evidence to the formulation of your case theory. There are 5 main stages that should concern you in the deployment of digital evidence for litigation purposes. First, identifying the evidence. Second, preserving the evidence. Third, extracting the evidence. 4, analyzing the evidence. And 5th, presenting the evidence. By way of a reality check, the first and last step are comfortably within the domain of the lawyer. However, the other 3 domains will require the input of a digital forensic expert. Please do not assume that your knowledge of how to use the internet and send emails will suffice to deal with the analysis and extraction issues associated with digital evidence. I don't intend to be mean here. I am just being very frank. I have seen lawyers in court during cross-examination completely pretending to know what they're talking about and end up getting confused in the process. I have heard a lawyer say, "This technology thing confuses me." That's not the kind of speech an advocate should be delivering in court. If you don't know, get someone who knows prior to court trial. Now, before you formulate your case theory, it is highly recommended you identify the relevant evidence. The proof of evidence supplied by the other side should provide sufficient pointers. In the event you don't have the proof of evidence, revisit your client's and witness statement, then secure the services of a digital forensic expert to examine any computer evidence seized from your client. Even where the prosecution decides not to rely on computer evidence, you might just find exculpatory evidence lurking somewhere in the abandoned exhibit. With respect to the other three domains, preservation, extraction, and analysis, you must work with your expert in order to review adverse report and provide your own probative evidence. If you do not have an expert, you may examine the adverse expert report and analyze for compliance with best practices. Where there is a non-compliance that is substantial enough and likely to prejudice the case of your client, you may file a preliminary objection to the use of the adverse evidence. Now, with respect to the deployment phase, assuming you have sorted your case theory and identified relevant digital evidence to aid your case, your strategy must now move from the office to the litigation arena. Before trial day proper, there is a lot of housekeeping required to ensure you successfully deploy your digital evidence strategy. I have grouped the deployment stages into three. 1. Pre-trial, 2. Case management, and 3. Trial proper. Remember, like every other species of legal evidence, digital evidence, to be admissible, must be authentic, relevant, comply with the hearsay and best evidence rule. All of these must be sorted at the pre-trial stage. The post-trial stage is also where you may wish to consider the necessity for specific disclosure of evidence, applications to obtain and examine evidence, consult with a digital forensic expert, request an interim forensic expert report, consider availability and ease of access to the evidence, consider cost of securing expert services, available time frame for delivering of expert report, and the availability of the expert for trial if required. If you've sufficiently addressed all of the factors, then you should be ready for a productive plea and case management hearing. From my experience, lawyers walk into a plea and case management hearing without the relevant facts to make a request or counter a request. In fact, some lawyers agree to certain court orders concerning digital evidence and only realize that they have agreed to an undertaking they cannot deliver on when later they consult with the expert. Please consult with your expert before attending the case management hearing. That is very important so that you can have a productive hearing. Now, let's look at the third stage. It is important to first confirm you have complied with any outstanding court order before trial, especially where it concerns the use of digital evidence. Where this is not possible, make certain the court is aware of your difficulties prior to the hearing date. Again, I have seen lawyers during the trial trying to explain why they have not complied with a court order on the use or production of digital evidence. It is hard enough to win a case, but to have an angry judge on the bench is not a salutary sight. During trial, get your expert to sit behind you. Ask court's permission if it becomes necessary. The courtroom is no place to start a new case strategy with the expert. Stick with your case theory. Do not go changing plans on the fly. In another of our lecture series, we have provided strategies, detailed strategies for deploying computer evidence and strategies to adopt during examination in chief and cross-examination of expert witnesses and digital document custodians.